Hi, this is Rahul Reddy. We're live here from Houston, Texas. We bring in business immigration every week on Tuesday at 5 p.m. Central Time. Along with me is Emily Neumann. Emily?
Thanks for joining us today on both Facebook and YouTube. We'll be talking about the upcoming H-1B lottery and whether there will be changes to how the lottery is conducted this year compared to last year. We'll also be talking about the August 9th unlawful presence memo for F1 students, what you need to know about it and be aware of, especially if you are planning on filing in the lottery in April. How will that impact? We'll also give you an update on the H-4 EAD and, as usual, answer any live questions that you have. If for some reason we're not able to get to your question today, you can always join one of our daily conference calls where we answer questions as well. Those are free. You can get the schedule and the dial-in information for that by going to rnlawgroup.com. And if you'd like a more detailed discussion with one of our attorneys to discuss your specific circumstances, you can go to rnlawgroup.com as well and schedule a consultation appointment with any of our attorneys. So, what updates do we have about the H-1B lottery? What's the plan for April 2019? Is it going to be the same as last year?
There is a proposed changes which the USCIS has published with regards to the April 2019 quota. We are not yet sure if they are going to implement that, but their proposal is that instead of us filing all the H-1B applications in the lottery and getting the rejections, the employers will be given a chance to register themselves up, and they can enroll the names of the employees for whom they want to file the H-1Bs. They need to give their first name, last name, middle name. They need to give their passport number and the date of birth, and then indicate to that they want to file the H-1B. No LCA has been required, no place of employment is required, but they need to give the details of the employee's name, date of birth, and also the passport number. And they will be subject to the online lottery system. Once they are selected in the lottery system, they will be having two categories. One category is for those people who are going to file the applications between April 1st and April 30th, and the next category is from May to the end of the May. There will be two set of the people. Emily, can you describe in more details about this?
Sure. So what they're proposing to do is to make the process more efficient and use fewer government resources in order to actually get all of the petitions entered in and start processing them. So basically, and again, this is just a proposal. The commenting period is open. We won't find out if they're going to proceed with this until probably early February, which is a little scary because usually we're preparing all of our petitions for filing well in advance of that. So what they want to do is open up a 2-week registration window sometime in the month of March. Once everyone registers, they'll run the lottery, and then they'll send out notices saying, hey, you've been selected, now's the time to file your actual petition. And they'll give 2 different filing windows in order to spread out the receipt of all of the petitions to make it easier for USCIS to handle all of that incoming mail. So the actual filing window, depending on your case, would be about a 60-day window, but there'll be 2 windows. So we'll actually have about a 4-month period from April 1st till June 30th in which everyone will need to file their petitions. As I said, the commenting period is open on this. Some comments have already been submitted. We have until January 2nd to submit public comments that can be for or against this proposal and ideas how to make it better. And I'll be posting a draft comment or a sample of what you can send, or at least how to send it, soon on my blog, immigrationgirl.com. I started working on that today. And we'll have that available for you soon. Now, because so little information is needed to submit the registration, and because there's no filing fee associated with it, I think that there is a high likelihood that the number of registrations will be way higher than the number of actual petitions that we normally see filed in the lottery, which means everyone's chances are actually worse of getting selected. So that's one of the downsides, that when they make it so easy to register, it might flood the whole system with lots of petitions or lots of registrations, and then it will be up to employers to figure out who they want to file for. I think one of the other major issues I have with this proposal is just they're doing it so last minute. Number one, is the website going to be ready? It probably is going to crash during this 2-week window, knowing our luck. And you know, like I said, we're normally starting to prepare petitions right now, and we won't know until February
what we're going to be doing.
We can't even file them. We've just prepared all of these petitions for people, and now we're going to do this electronic registration instead. You know, and if we wait and don't prepare them, and then they say never mind, we're not going to do it, now we're really behind on getting everything filed. So it's just horrible timing. I don't know why they didn't announce this
like
in June,
4 months before, 5 months before,
or you say, yeah, we're going to announce it now, but it's going to take place for the following April 2020, not April 2019. It's just lots of problems I see with this proposal. And then the other part of the plan is to modify the order in which the lottery is conducted. So up until now, there are actually 2 lotteries that happen. One is for the bachelor's cap, $65,000, and then they do a lottery for master's cap to select only 20,000 of just master's applicants. Now, up until now, they've run the master's lottery first, picked 20,000, and then anyone who has a master's who was not selected gets put into the general lottery for the remaining 65,000. USCIS wants to reverse that, do the 65,000 first, and then of the master's cap applicants who were not selected, put them into the new lottery for just the 20,000. They're suggesting that this will increase the ability of U.S. master's degree holders to be selected in the lottery, which goes along with President Trump's merit-based immigration. However, you know, a lot of people are pointing out that that is kind of opposite of what the statute says about the master's cap. The master's cap was created by Congress. It's a law. It is a statute. It's not just a regulation that the Trump administration can change. And it says the master's cap exemption, they exempt the first 20,000 petitions from the lottery. So if you're talking about the first 20,000, that should be done first, not the last 20,000, exactly. So can they even make this change without going through Congress is going to be a big question in everyone's mind. So everything's up in the air right now. Unfortunately, we don't have answers, and we
Emily, I think so we've talked too much technicality. Coming into the picture right now, if I were the applicant and I have a job with company A, what do you suggest me here? Go to Congress? Of course not. What do you suggest? Should we prepare the application or wait until March? What exactly are you telling me?
Yeah, it's. I think it's going to be up to each company to decide how they want to proceed
what
with that.
What do you advise? Because I'm an applicant right now. I can go and sit down with the HR, explain to them based on the reading. But I'm proposing, you can argue with me on that this lottery system is a little bit shaky at this point of time, the way the online system is designed. They also put a caveat that we may or may not implement because of the technical issues this year. I would suggest the applicants at this point of time to prepare the H-1B application, and if the lottery system comes online, obviously, and of course, and you must register yourself, the company should register and do it online system. But I would not like to wait until March and then decide what I want to do. What do you say about that?
Yeah, we actually, our whole team of attorneys discussed this in our staff meeting this morning. That was our exact kind of outcome. What we all decided was we're going to suggest to our employer clients that they proceed, start working on them now, start initiating LCAs as if this lottery electronic registration process does not exist, so that we'll be prepared in the event that USCIS does an about-face, which they've done many times before. They did it with the third-party placements demo PT memo. They did it with the NTA memo. They just start things and then stop things. With the initial travel ban was a big mess how they tried to implement that. So this administration is not really known for coming up with a plan, a well thought out process, and implementing it in advance so everyone knows what to do. And so we're going to be guiding our clients to go ahead and start preparing as if this registration doesn't exist.
And when the electronic registration does it, go to register the electronic.
Exactly. Then we'll be prepared either
way. Otherwise, if this one doesn't go through and you file an application the April 2nd week, you're going to get the automatic rejection. So that's good. Emily, as we have noticed that in the 2017 we started getting denials, 2018 we are getting denials for different reasons right now. Not just the technical manual preparing the file. What should be the applicant be wary about when they are filing the H-1B application in April? Selecting the lottery is definitely one of the things. There is not much they can do about it other than filing an application. But once it's selected in the lottery, you still need this H-1B to be approved. We have noticed a significant amount of denials last year. What are the precautions that you would suggest people to do?
Yeah, I think the number one thing to think about is the job offer itself, the job title, the job duties, the salary that's being offered, because those things are factors USCIS will look at to determine whether the job can actually qualify for the visa, meaning is this job a specialty occupation? We're seeing tons of denials on that issue this year compared to past years. Jobs that everybody normally would agree should be clear it's a specialty occupation, USCIS is coming back and questioning and sometimes denying. I mean, I just received an RFE today for a civil engineer asking me if to prove that that job requires a bachelor's degree in civil engineering. You would think that it would be clear from the job title alone, the type of company, the person has the civil engineering degree, has the license, all of those things, but that's not good enough anymore. So there's not really a way to 100% avoid all of these RFEs, but you can set yourself up for success if there is an RFE by selecting a strong job description, a strong job that we know has a higher chance of success. And that will help us determine the correct SOC code. USCIS looks very closely at the SOC code because that's how they will look up the job in the Occupational Outlook Handbook. That's where they look to determine what the normal education requirements are for a job according to the Department of Labor, and they rely heavily on what that Occupational Outlook Handbook says. So if you know what SOC code is going to be used for your petition, you can go to the Occupational Outlook Handbook, just Google it, and then you can type in your SOC code and read what it says about how to become one. Every single type of occupational code, almost all of them anyways, has all these sections about what this job normally entails, how many people have this type of job, what's the job outlook for the future, and most importantly, what education does this job require? It's usually a paragraph that says this job normally requires a bachelor's degree in X field. That's what you want to see. The problem comes in when it says some employers require a bachelor's degree, others do not. That suggests it's not a specialty occupation. Or if it says that this job requires a bachelor's degree in X, Y, Z, A, B, C, D, or E, all these different fields of study, that leads an officer to conclude, again, it's not a specialty occupation because there's not one field of study that qualifies someone for that job. So that's the number one thing you can do to improve your chances of success is pick the right job to file your petition for, and verify what SOC code is going to be used, and then look that up in the Occupational Outlook Handbook to see what your chances will be. The wage level is also a very important factor. The higher the wage level, the easier it is to prove that maybe this particular job is more unique or more complex, and that because it has that higher wage level, it must require a degree. Other than that, it's just finding out about your company that you're looking to be sponsored by. What's their success rate? Are they familiar with the H-1B? Have they filed these before? Have they had approvals before? Are their HR knowledgeable about what's required to get an approval? All of those things are important things to consider when you're getting ready to file.
It's better to take care of all these things before you file an application. Once you file an application, you're stuck with the material that you have submitted to the USCIS. If you gave a material where you said that a particular position is what you are getting hired, and if they don't meet the requirements at a later point of time, you cannot change it. Your H-1B will be denied if you change it. So it's better that you do it right now. Don't wait until March to do all that activity. At that point of time, the lawyers will be busy, the HR will be busy. It will be very burdensome for everybody. So if you wait until the H-1B is filed, you're going to be harmed. Very much good chance for it. If you wait and you get the RFE, then I'm going to take to a very good lawyer to respond to the RFE. No, that doesn't work that way. If you file the application in a wrong category or not so good category, your chances will be very less for your approval. So it would be better that you discuss all these things with your HR and necessarily and probably with your immigration lawyer right now, not just before 1 week, not after filing that application, well before. Otherwise, you will be in trouble. Emily, I want to move on to the other topics, which we quickly are going to cover about this August 9th memo. Why the August 9th memo? It doesn't say anything about CPT, day one CPT. How come you've been kind of repeatedly telling that that August 9th memo is applicable? And because if the plain reading of the August 9th memo does not say anything about day one CPTs, and there are a lot of other, universities, some universities, I would say 5 universities, that are issuing the day one CPTs. And what is this August 9th, 2018 memo has to do anything with the day one CPTs?
Right, so this memo, yes, you're right, it has nothing to do with CPT. It does not mention CPT, it doesn't mention STEM OPT, really doesn't mention anything about all of these different programs that F1 students can become involved in. Now, which is what makes it so important to understand the impact of it, because the memo itself just applies to situations where there's been a violation of F1 status. The memo says if you violated your F1 status and USCIS makes a determination that you violated your status, you will be unlawfully present from the day the violation began. That's never been how USCIS interpreted this before. In the past, if there was a status violation and USCIS makes a determination that there was a status violation, you will be out of status and unlawfully present from the day the decision is made going forward, not going backward to when the violation occurred. Now, the issue that comes up is when these status violations occur, it may have started 6 months ago. It may have started a year ago, because these day one CPT programs, for example, are giving people CPT for years at a time. And so we see people who've worked using this CPT for a year, they're going on their 2nd year, and at some point, in our experience, USCIS is going to make a determination that that CPT was not properly authorized. Then that leads to the conclusion that you violated your F1 status. That leads to the conclusion that you've been unlawfully present from the day the violation began. Now, what's really important to be aware of is the 3 and 10 year bar regarding unlawful presence. This provision has been around for years, but we've not really heard about it in the sense of F1 students, because until now, F1 students have generally been given duration of status on their I-94, that's that D/S, which means you can't really overstay and become unlawfully present. Unlawful presence has generally meant you overstayed your I-94. Because students were never given an end date, it was impossible for them to overstay unless USCIS made a determination that a status violation occurred. And again, in the past, that meant unlawful presence started from the following day after the determination. Now everything is retroactive, and with that 3 and 10 year bar, it means that if you have 180 days of unlawful presence, you're going to be barred for 3 years from returning to the United States. If you exceed 365 days of unlawful presence, you'll be barred for 10 years. So if you are planning at some point to change your status from F1 to H1 or to some other type of visa application, if the determination is made that these day one CPTs were a violation of status, you could trigger the 3 or 10 year bar without even knowing it. And no one realizes it yet because we haven't hit 180 days from August 9th yet. I think a lot of people are going to find out after it's too late that they're subject to the 3 year bar in February of 2019 when they receive the denial of their change of status to H-1B because they've worked in these CPT schools that were not properly authorized. They will end up with a 3 year bar. We will start seeing that coming this February.
And they may be issued notice to appear because they violated the legal stay.
Exactly, yeah. On top of all that, we have the NTA memo in which USCIS said if on the day a decision occurs, you are unlawfully present, we will issue an NTA. Now, as of right now, they've only started doing that for I-539 and I-485 denials. They've expanded it to some other categories, not to I-129s yet, but that is coming. So who knows by February if they
I want to
forward
quickly
with that.
ask some questions about the maintenance of status. There are a lot of questions coming, Emily, and then I want people to understand the thing. So I'm going to go quickly ask the questions to you. I find I'm on the STEM extension OPT and I'm working at a third-party location. Is that it, or do I have to maintain the status? Is there any maintenance of status on the STEM extensions? What should I be careful if I'm on the STEM extension?
Yeah, the STEM extension has more specific requirements. Number one, it must be a paid position and it must be at least 20 hours a week, must be an E-Verify employer, and you must have a valid bona fide employer-employee relationship with that employer, which means if you're at a third-party site, the employer must have a way to supervise you and comply with the I-983 training plan. So if in the training plan the employer said they're going to do X, Y, and Z in order to get you additional training that's on-the-job training, they actually have to do X, Y, and Z and be able to document it. So it's not enough just to say, well, I'm working.
Have you seen any denials of change of status for those things?
Yes, in this year's CAP, the April 2018 lottery, we've seen requests for evidence asking about maintenance of status specifically during the STEM OPT extension, and USCIS was not satisfied that the employer-employee relationship was there and that the employer was actually supervising the person properly when they were at a third-party site. They've denied the change of status. That invokes the August 9th memo, puts the person in unlawful presence since August 9th. And if that kind of denial happens after February, these people are going to be barred.
Do they need to do anything when they change the employer?
Yes, you have to update your school and submit a new training plan if you're on the STEM extension, and the school has those 6-month reporting requirements. They're usually sending out an email saying you need to report in, where are you working, what are you doing. You have to comply with those as well.
If they change the end client, do they need to report anything on it?
Yeah, because that is going to be a material change to your I-983 training plan. Speaking of that, if you're in third-party placement, your training plan needs to specify where you're actually working. It can't say that you are working in-house at your employer's location when you're actually at a third-party site. You have to list the proper address where you're working on the 983
Are there
form.
any updates that the employee needs to do on the 983 and reporting to the USCIS that you have seen some problems?
Yeah, other than anytime there's a material change in the training plan or in the job, in the work location. Those all require the 983 to be updated and submitted to the school. There's also the 12 and 24-month self-evaluation that you have to make sure you comply with that and turn it in to your school on time with your employer's signature.
Last question. How many days of unemployment is allowed in the OPT and STEM extension total?
So for the 12-month OPT, you can have up to 90 days of unemployment, and on the 24-month STEM extension, you can have a total of up to 150 days of unemployment. And USCIS does also verify that. We've seen it in H-1B petitions where they request evidence of the pay stubs during the entire OPT time to show maintenance of status, and if there's any kind of gap in those pay stubs, they assume you were unemployed during that gap, and if it exceeds those time limits, then they'll again assume you were out of status.
I just want to update on the H-4 EAD. There is no update on the H-4 EAD. You can still apply for the H-4 EAD. You can still file for the H-4 EAD extensions. There is a possibility they might come with the proposed regulations, but as of today, everything is good. If you are eligible for it, go ahead and file for the H-4 EAD. Let's go back to some of the questions that I have. Here you go. I have the questions from Abhilash. He got his change of status of H-1B got denied. He's on CPT. Should he leave the country or what should he do?
I think most importantly, you need to speak with an attorney about your specific situation, have them review the denial notice to understand what the impact is going to be. If the denial of the change of status was due to a status violation, such as unauthorized CPT, then that denial means unlawful presence kicked in from August 9th. So you have to be really careful about counting your 180 days to make sure you don't exceed that. Otherwise, when you do leave, you're going to trigger that 3-year bar. So because each denial is very case specific, the best thing I can say is to set up a consultation with any qualified immigration attorney to understand what your options are and what you need to do in order to make sure that you're not subject to that 3-year bar.
I have this question from Anil where he's asking the cross portability. I'm assuming whether it's cross chargeability or cross portability. I'm going to answer either of those things. Cross portability, you can port the date from EB2 to EB3, and you can port the date from EB3 to EB2. You can do the same thing with EB1. You can do any way, EB1 to EB3, EB1 to 3, whatever way you want to do it, you can do it. Absolutely no problem. After the I-140 is approved, yes, you can do that. There is also called cross chargeability. I don't know if that's what you meant. Cross chargeability is that if, for example, you are born in India and your wife is born in Dubai, United Arab Emirates, even if she is not a US citizen of UAE, United Arab Emirates, she will be considered as a UAE for the purpose of the cross chargeability. Since their priority date is current, you can file the adjustment of status. So if by any chance, if anybody is an Indian citizen, either the main applicant or the spouse of the main applicant, if they are born outside India, you need to check with your lawyer because there is an easy and faster way of getting the green card. Any questions from the Facebook?
Yeah, Shah has a question about the LCA. He's been hearing that there's some technical issues and the applications are not going through. I've been getting that question a lot on Twitter as well, and I can tell you we've not had any issues getting LCAs certified. It is a new LCA form, but they're being certified within 7 days, just as they always have. So I don't know where people are looking to see these LCAs, or maybe there was something filled out. The form is a little bit different. It's a little counterintuitive. There's certain boxes that you would check differently than before. So maybe that is causing some delays, but for our firm, we're not having any issues. So the new LCA form is working fine.
Jay has this question, my I-94 is expired and my extension got denied. What should I do? You should leave the country immediately, sir. That is the best thing that you could do, because once the I-94 is expired and your H-1B extension got denied, you are accruing the unlawful presence. You need to leave the country. Another suggestion what I would give to everybody is that if your H-1B gets denied, whether it's a change of status, whether it's an extension of status, whether it's an amendment, I would strongly advise, because that is something that is, it's like, it's your stay in this country, your undocumented stay in this country. You should consult a legal professional immediately. once your H-1B is denied, because you will be accruing unlawful presence. There are a lot of other consequences that will be there. There are some temporary fixes that you can do it when you consult a lawyer. There are some things that cannot be done. You might have to leave the country, but that's a decision that you need to make after you consult a lawyer.
Chetan has a question about those F1 maintenance of status RFEs that we've been seeing on H-1Bs. If you received that type of RFE, is it possible to just change your application to consular processing and not provide the documents requested about maintenance of status? Yes, it is. We have done that in several cases in our firm and have had positive results in it. Once you request consular processing, generally you're not required to establish anything related to your status, because it's assumed that you will be outside the country applying for a new visa stamp at the consulate upon approval. But I would, again, discuss with your attorney to make that determination, to understand all of the impacts of changing to consular processing and how that might benefit you in having a higher chance of success with the H-1B.
Priya has this question. Her I-140 has been approved. It's 180 days. The employer is not sharing the I-140 information. Can she file a FOIA information and the employer would not know about it? Yes, that is right. You can file a FOIA, Freedom of Information Act, online with the USCIS for your I-140. The employer will not be notified that you have been filing a FOIA. So you can do so, absolutely. And this is for all the people that we're suggesting. If the employer is not sharing an I-140 approval, we would like you to go to USCIS and our website and file FOIA, Freedom of Information, and you can get that. It's taking about 45 days to 90 days for you to get the I-140.
All right. Ravish has a good question. Any drawback to downgrading from EB2 to EB3? It really is going to be looking at each case individually. There are some potential issues. Anytime you file something with USCIS, you have to prove you meet all of the requirements each time you file, even if you were previously approved. So if there are things that happened after your EB2 I-140 is approved that might impact whether you could get the EB3 I-140 approved, definitely there are some risks there that the EB3 might not be approved. So those should all be looked at thoroughly before filing. But in general, as far as the position that you're being offered, does that have to be different? Does it have to be downgraded to qualify for EB3? Almost always no, because an EB2 position will almost always qualify for EB3 approval with the same labor certification sponsored for the same job. But definitely before you file that downgrade, you should let your attorney know that what your concerns are. Make sure they thoroughly review the I-140, look at all of the immigration history in your case to make sure there aren't going to be issues there, so you have a good chance of success with that. But we've been doing it. We've had good success so far with our downgrades.
I'm going to go through some quick questions from YouTube. Ravi has this question. Is there any downside from downgrading from EB2 to EB3? Unless your priority date is current, I wouldn't do it. There's no need to do it. But if your priority date is current under EB3, there is no downgrade at all in downgrading. There's no downgrade at all in downgrading to EB2 to EB3. You will have both the options available to pick and choose, though. Another question is from YouTube is, while the H4 EAD is pending, can I travel outside the country? It's very clear based on the question that the H4 approval validity is there. It's just that the EAD is pending. If the H4 is not pending, and if the H4 validity is still there for, let's say, 2020, and you file a EAD, you can travel absolutely no problem. EAD will be adjudicated whenever the time comes, which is approximately 90 days to 100 days.
Akanksha has a question on Facebook. Can I do a part-time job along with my full-time job when I'm on H-1B if the part-time job does not pay? No. You're only authorized to work for your H-1B employer even if some other job is not going to pay you. It is unauthorized employment. Regardless of whether you're paid or not, you can't do that. You can only work for the company that sponsored you when you're on an H-1B.
Question came with regards to the H-1B extension, how far the LCA can be filed, how before the LCA can be filed. LCA can be filed 1 year before, but the extension can only be filed within 180 days before your H-1B expires. LCA can be filed before, but the H-1B extension can only be filed within 180 days.
All right, Pawan asks, who's here on an L1? Can a different employer sponsor his green card? Yes, the green card is for the future permanent position you'll move into when you actually receive your green card. It does not have to be the same position you're in now. It doesn't have to be the same employer now. There are some potential risks of filing a green card with a different employer that you're not working for, especially at the I-140 stage regarding ability to pay. So that needs to be thoroughly looked at before proceeding, but there's no restriction on that.
Jay has this question. I-94 has expired, H-1B extension is still pending. How long can you work? If the I-94 has expired, from the date the I-94 has expired, you're allowed to work up to 240 days. If you're coming near the 240 days, way before, I would recommend that you contact a lawyer. There are different ways to extend that 240 days, but I would recommend that you contact a lawyer on that. There are some risks involved in it. Jagan has this question from YouTube. His girlfriend, or about the girl that he is about to be married, is born and is a Nepali citizen. Is he eligible for cross-country chargeability? Yes. Even though you are the main applicant, if you are married to a Nepalese girl, and that country will be counted towards the number for the green card. That is called cross-country chargeability. Yes, your priority date is immediately current, Jagan.
All right, Jitender has a question on Facebook. Was laid off from company A, already filed a petition with company B, and it's waiting due to the premium processing suspension. Is everything okay with that? Well, assuming you're working for company B, that's fine, as long as company B's petition was filed within 60 days of when you stopped working for company A, and company A's I-94 validity is there. Yes, you can file the transfer within 60 days and start working for company B to maintain your H-1 status.
Can an employer file H-1B extension when H-1B extension is expiring in 15 days in regular processing? Yes, they can file in regular processing. It's nothing illegal, although we don't suggest that they do. But yes, even if your H-1B expiring in 15 days, they can file in regular processing.
If I'm on STEM OPT, is now a good time to travel? It could be problematic. So when you are entering the U.S. on an F-1 visa, you have to prove to the officer that your intention is to study in line with the F-1 visa. If you are already on your STEM extension, you've graduated some time ago, so you no longer have a program to study. On top of that, you have to prove to the officer's conclusion that you are planning on returning to your home country at the end of your STEM OPT extension. So that may be difficult for you to prove if you're coming here for employment, you're planning on filing an H-1B in the future. So there are chances that you could be denied entry at the port of entry, or if you need a visa stamp, you could be denied the visa stamp as well for those reasons. Risky to travel at that stage.
Question that comes out in YouTube is that can I move to company B from company A on a H-1B transfer receipt notice? Is it safe to move to company B on a H-1B receipt notice, Emily?
It's never going to be 100% safe. There's always a risk anytime you file something with USCIS. So it really depends on how much validity period is left on your I-94 with the current company, as well as whether they're planning to withdraw when you leave. And it really depends on the job offer with the new company. How strong of a case was it? We can kind of see in advance there are certain cases that we know are going to be weak cases, and those might not be the best ones to switch to based on the receipt notice. If it's a stronger case, then you've got less risk by switching employers based on the receipt. It really depends on the strength of the case.
I got this question on YouTube. Can I file 2 applications on the H-1B in the April 2019 quota? Our strong advice is no, you cannot. There is a lot of fraud that is going on when the companies are filing for the people who are not working, because they're not only filing for you, but they're also filing for hundreds of different people. And according to the new proposed regulations, which are going to be finalized pretty soon, if an employee is selected in the lottery and the employer does not file an application, there most probably will be a criminal prosecution on the employer. And you don't, as an employee, you don't want to conspire with the employer in doing that criminal activity, because when the employer is attesting to the fact that there is a job offer open there, if he does not have it, that is considered fraud. No matter how you design me, how you tell me, if you're filing for duplicate H-1B in the quota, we tell you that this is a fraud thing. You do not do that thing. And we have seen so many people getting into trouble. In sometimes they have approved both the H-1B approvals and they revoked both the things afterwards, making them out of status. So we do not want you to file the duplicate H-1B applications.
Yeah, and just because you got that approval and you now have transferred to a different company and maybe a different company after that, don't think that you're in the clear. USCIS will come back and revoke the original approval. That means you're no longer exempt from the cap, which means every transfer you've filed since then is subject to the cap. So if you didn't file in the lottery, you basically have no H-1B at all. So you really don't want to put yourself in that situation. It's just not worth it.
I will go to the questions. Is the premium processing still there for the same client extension? Yes, you do have the premium processing still there. If it's the same end client and you're filing an extension, that process is there. Vinu has this question, can I change to B1 to B2 if the H-1B transfer gets denied? No. If you move from company A to company B and you're working with company B, and if your company B's H-1B transfer gets denied, that means that you are out of status. Once you're out of status, when you file for the B2 application, it will not be approved because you have to maintain the status until the B2 has been filed. Now, also, since you're not working with company A, we call the application with the company B as a bridge application. Since the bridge is broken, the B2 will not be approved. There are also other consequences that you need to remember, that you may not be qualified for B2. What's the purpose for you to stay in this country when you don't? Is it for visiting? Is it for business? So that also might be a violation. You may want to check with your lawyer on that before you do any of those activities.
All right. Can I file an H-1B extension if an amendment is pending? Yes, you technically can. If there's enough time, it might be best to get the amendment approved first and then file the extension. But if your I-94 is expiring and your amendment is still pending, you'll have to file the extension. Just be aware USCIS might hold the extension petition and request a copy of the amendment approval before they'll proceed with approving your extension. Calvin asks, he's got the H-1B pending with an RFE. STEM OPT extension is ending soon. Should I try CPT? No. Please stay away from these schools that are giving you CPT at the same degree level or within your first 2 semesters of grad school. Based on how USCIS is viewing them, they are looking at these as not being properly authorized, putting you out of status and unlawfully present.
I have a question, Emily. You wrote an article saying that the same degree, CPT, is definitely not legal. And I get a lot of these questions from that article and further articles. And then now they're saying, no, I'm now going to move to doctorate degree and get the day 1 CPT. Is it legal to do that thing?
So that might overcome one issue, which is USCIS has a problem with CPT at the same degree level that you've already graduated from. but it still, to me, is very unlikely that that is a properly authorized CPT. I've been in a PhD program before. I quit the PhD program and switched to law school because it was easier. But when I was in the PhD program, I can tell you there is absolutely no way I could work outside of doing that program. This was in biomedical science. I was in the lab constantly at the school or studying. There was no time, if I was going to maintain any sense of a good grade point average, to be able to work. And especially these schools that are claiming that you can work 40 hours a week and be studying a PhD program, I would really question that PhD
Study
program.
PhD program on YouTube. Don't forget that.
Yeah.
So no, just because you move to a doctorate level program, day one CPTs, we are absolutely not recommending. It's just because you move to a higher level degree, still the day one CPTs are not legal. Remember that. There are only 4 or 5 universities that are issuing. And we know 2 of those university names starts with C. I don't want to name them, okay? Those 2 C's are issuing about 50% or 80% of the CPTs in the entire nation on the day one. So be wary of those 2 universities.
Do you see any issues right now with someone going for H-4 stamping if they have valid H-4 through, next September, let's say? As an immigrant, as an immigration lawyer, I don't want people to go out for stamping when they don't need to. But as such, H-4 is probably the safest visa for you to apply in the consulate compared to F-1, H-1, O-1, P-1. I mean, name all the visas. H-4 is considered to be the safest visa of all the visas. The chances of success of the H-4 is very high compared to any other visas because they're typically looking into the relationship between you and your spouse. If it's a genuine marriage, which I doubt. If there's any fake marriages, people will apply for H-4. So those are good visas to apply in the consulate. Can I go out of the country when my H-1B has been filed for an extension? Well, yes, you can go out. The problem is, how are you going to get back? You have to wait outside until your extension is approved, apply for the new visa stamp, get the visa stamp, and then come back. So you can go out, but you can't come back in until you have the approval and the visa stamp. So that's very risky because what if there's a request for evidence, there's no premium processing, you might be stuck outside for months waiting.
What is the current trend in the RFEs for the H-1B extension?
I think it depends partly on the service center, if it's an extension with change or an extension plus an amendment versus just a regular extension that can be filed in Nebraska. In Nebraska, the main RFEs are related to maintenance of status during the previous 3-year H-1B validity. They're asking for 3 years worth of pay stubs. They're also asking to prove specialty occupation work is available for the next 3 years going forward and that the employer-employee relationship will exist for the next 3 years. If you're filing in Vermont or California, then they're looking at everything again. They're going to look at your qualifications again. They're going to look at employer-employee relationship, specialty occupation, maintenance of status, you name it, they're looking at it if it's going to one of the other service centers.
Prashant has this question. He has a F-1 visa that is expired and now he has changed to the H-1B visa. Can he travel to Canada and come back without any visa stamping if he has a valid I-94 on the H-1B? Yes, you can. There is no problem with it as long as you're traveling to Canada and you're coming back within 30 days and you have not gone outside of Canada and you have not applied a visa. So if you went there and you apply for the H-1B visa, if the H-1B visa gets rejected, then you cannot come back on the valid 797 I-94. But if you just go, you're just skiing there, nice time for skiing, and then you come back in 30 days, you do not need the visa if you go to Mexico or Canada.
Raj has a follow-up question. We talked a little bit about traveling on an F-1 where your program has ended, you're on OPT. How are you going to prove your intention is to study and not work and that you intend to return home at the end? He is planning on filing an H-1. Is that going to be a problem just because he's filing an H-1? Well, filing the H-1 on its own is not a problem. The issue that comes up is when you're entering the country or you're applying for the visa stamp, you have to prove what your intention is. Once you're already here, you can change your intention and later choose to file an H-1B. That's generally not a problem as long as it's not done immediately after you enter the country. So there are different issues involved with all of that, but generally when you're filing an H-1B change of status, they're not going to be concerned as much about what your intention was on the F1 unless you entered very recently on F1.
Thanks for the questions are pouring, but I think it's time for us right now to close up, Emily. And for those people who we are unable to attend to these videos that we are presenting, we have a daily conference call. You can always check at rnlawgroup.com. We do allocate half an hour every day for you guys to ask questions. You can also, Emily, about your blog.
Yeah, if you want to get the latest updates, breaking news, specifically for employment-based immigration, practical information that you know impacts you without the hype and sensation and fake news that's going on, you can visit me at immigrationgirl.com and subscribe there. I promise I'm not going to send you random emails. It'll just be whenever I post a new article, you'll receive an email with that. But you can comment on those articles as well, and I answer a lot of questions there every day.
It's www.immigrationgirl.com. Thank you guys very much. Thank you.